I was here for I had Davcado TV. Say when you subscribe to Davcado TV, I log on to YouTube. Davcado TV. We are on YouTube. We are on Facebook, and I saw a TikTok. We call Instagram also. We have Davcado TV. Now Davcado TV, no, you can follow us on all our social media channels. Davcado TV. Davcado TV. Yeah, to us with the legal processes. Also for the impeachment of what Chief Justice Torkorno. There has been several petitions to remove Chief Justice from his office or from her office. Yes, Justice Torkorno, Gertrude Saki Torkorno, or no, the Chief Justice of the Republic of Ghana, and there has been several petitions. I have petition against or no. Say I was say offering office, and that petitions has been submitted to the judiciary, and then the president has to come in. President and nominate the committee, and also set up committee to what? To investigate, and I say to go into inquiry, and then they make sure say the petitioner ya presentee for the impeachment of Chief Justice, no, it will be looked upon, it will be investigated, it will be query into they've started the process. The committee has started its work, and then whenever the committee is working, then there will be an injunction. A crata say court proceedings, no, you can bring an injunction to stop it and to put a hold on it. That is an injunction. It's a legal order to stop the proceedings of a legal matter that is before the law court. So Supreme Court has thrown the second injunction out. There has been an injunction to halt the processes, and I said the impeachment, not no. But Supreme Court has thrown out the second injunction. This is the second injunction. The first one by and also almost trashing it out. They thrown it out. And the second one number. So let's just read something from what happened today. They were in court today. The Supreme Court has thrown out another injunction application that sought to halt the impeachment process against the Chief Justice Gertrude Saki Torkorno. The 4-1 majority decision today, until today, 21st of May, they went into vote. So the majority decision presided that the court presided over by the acting Chief Justice. So since the impeachment is going on, there is an acting Chief Justice, I friend with Justice Paul Bafo-Boni, held that the application by the Center for Citizenship, Constitutional and Electoral System had no remit. So they are trying to say that the application that was filed to halt the impeachment process, no, it has no remit. It means any substances to substantiate what they are claiming or what they are trying, to put before the impeachment process. So Justice Bafo-Boni, Isifu Omoro Tanko Amadu, Emmanuel Yoni Kolendi, and Henry Anthony Kofi were on the majority side. So this is the vote that went on. When the injunction came to halt the process, they have to vote, and then the majority, carries the vote. So they have to throw the injunction out. This is the second time the Supreme Court has dismissed an injunction application seeking to halt the impeachment process, with the first one being an application by a member of parliament for Old Tafo Pankrono. So first one, MP, and I say member of parliament, on the kind of injunction, they have no right to impeach, and I say to sack, and I say to remove the Chief Justice into the injunction, but almost throw that injunction out. So this is the second one. This is the second injunction that is coming so far. So let's listen to the legal advisors, and I say, let's listen to what some of the lawyers are saying. This is one of the lawyers, expression lawyer Amaliba. Let's listen.
The Constitution provides for how these matters are to be dealt with. And so you have no discretion to decide to, as it were, breach the Constitution because you feel that you want to waive that right. That right, if it's granted, amounts to she and the Supreme Court colluding to breach the Constitution. And I think that is what the Supreme Court would have to guard against.
Okay. So stay with me. I want to bring in John Darko. John Darko, give me your own thoughts on this.
All right. Thank you. Good evening to your viewers. I think it's very interesting that when it suits us, we think that the Constitution is so entrenched, and when it doesn't, then we believe that we can step aside the constitutional provision. We were in this country less than 2 weeks ago when the president left the country, when he knew that the Speaker of Parliament was not in town, the Vice President was not in town. The constitutional provisions and the case of the same Asari Attorney General, the Supreme Court has interpreted the provisions so clearly that you couldn't leave the country without swearing in either the Speaker of Parliament to act. But the President left the country breaching the constitutional provision, violating the constitutional provision, and we didn't hear our brothers, or at least the panelists here, condemning the breaching of the constitutional provision. And so sometimes I wonder why we always want to do this to ourselves. We want to treat the Constitution, as if it's a convenient document that
Is there a constitutional? Is there a constitutional basis to waive that clause that says this process will be held in camera?
So look, if you look at Article 146 A8, which talks about the fact that the committee shall sit in camera, I think it is a basis for which my co-panelists are saying that the provision is so clear and that you cannot do anything about it. But we know that this same Supreme Court, our Supreme Court, has interpreted shall, okay? Because we are talking about the fact that the Constitution says it shall be in camera. The Supreme Court has interpreted shall.
Helen Haxel was able to win.
Not that provision may not necessarily be binding. In the Akufo-Addo and Mahamad's case, we know how the Supreme Court interpreted shall, and so the fact that Article 146.8 says that the whole act shall be held in camera does not necessarily mean that we cannot interpret that to mean that this should be open to the public. Look, this is a matter of public importance. And if you look at our provisions, Article 281, this is more like a public inquiry. And the law is very clear that when it comes to public inquiry, unless it's going to be against public order, public morality, or public safety, these kinds of hearings must be in public. And so I don't think that it is so rigid, so difficult that we cannot grant that request. Look, I think that it's in the interest of justice. The people of Ghana deserve to know what is going to go down in this historic action that has been taken by the president. Look, we've seen the Supreme Court at least open up our courts to camera, to public. We know in the two election petitions, the court decided that they will hold the thing in public, even though our courts, okay, are not allowed to broadcast trials, in public. But
so today, 21st May, what happened in the courts? The Supreme Court, the Chief Justice Torkorno, file a petition said they should remove her in the office. No, also a file suit against the defendant, and some of the defendants our file suit against is Attorney General, Justice Palmer, Justice Adibu Asiedu, Daniel Domelevo, Major Flora Dalugo, then Professor James Gisa. Onuangasa Sisiano, the same person who is the Chief Justice of the Republic of Ghana, or no, and a file suit against the defendant, against the people. Say suspend. Let me just go through this. Suspended Chief Justice filed suit at Supreme Court. See, Onuangasa filed suit against the defendant, and some of the defendant are 6. Defendant no file suit against them. No, 6. Attorney General, Justice Palmer, Justice Adibu, Daniel Domelevo, former Attorney General, Onusu, Major Flora Dalugo, Professor James Gisa, this year Onuangasa Ayeden a file suit. The Chief Justice has the right to a public hearing, removal proceedings, and may waive in camera privilege. So right now they are trying to argue that why is the proceeding shown in camera, because it's supposed to be a legal matter that is being shown and as being carried out in the court. Why is it shown in the camera? Because I say it will be of a disgrace, kakra. But the law is also saying that they can show it. Yes, the prima facie the determination was improper and is therefore now void and unconstitutional. So let me just clarify what the prima facie says, or what the law says about the prima facie. So just the definition of the prima facie. The prima facie means that it is based on the first impression, accepted as correct until proof otherwise, until proven otherwise, or until proof otherwise. So prima facie in Latin is at first sight, so or on the face of it. Prima facie is used in court to indicate that there is sufficient or adequate evidence to support a claim. You see, what is going on now, the removal of Chief Justice, now they are trying to say that the prima facie in there is that there is enough evidence to support the claim that she has to be removed from the office. This is Davcado TV. We will come your way with the next episode of the proceedings until the Chief Justice is removed, and until we get to the final conclusion of this Chief Justice removal. We will still come your way again. Thank you.